Before we get to some of the obvious news and some not-so-obvious news, I want to focus, at least temporarily here, on a great decision in the 11th Circuit, where 2 out of 3 judges ruled that which means the panel ruled that the individual mandate in Obamacare is unconstitutional. One of the judges was appointed by Bill Clinton. And one of the great litigators at the appellate level is an old buddy of mine from the Justice Department days in the Reagan-Meese administration. And that's Mike Carvin, an attorney at Jones Day. Mike, how you doing, bud?
How are you, Mark? How's everything?
Very, very well. I want to congratulate you and all the other lawyers who worked on this.
Yeah, it was a team effort, and obviously quite a day.
Well, tell everybody what happened.
We represented the NFIB, and there was also 26 states involved in the case. And as you pointed out today, the 11th Circuit Court of Appeals on the case that came out of Florida affirmed that the Obamacare health care legislation exceeded Congress's power under the Commerce Clause and deprived individual liberty and invaded traditional state prerogatives, so they struck it down, the individual mandate part of that law.
And they couldn't be clearer about it, could they?
No, they made a couple of very good points. These are people, basically what this law does is require you to purchase a product that you don't want. And Congress has the power to regulate commerce, but it doesn't have the power to make you buy into commerce, to become a market participant. And if they had that power, they would have virtually unlimited power because they could make you buy any product. And they also made the point that the real purpose of the individual mandate, as the congressional findings show, was simply to conscript healthy individuals to subsidize unhealthy individuals who other parts of the Act made insurance companies cover. Instead of having the federal treasury pick up the burden for the social welfare mandated by the Act, they were conscripting innocent individuals who had no contact and were not responsible for the problem. So this was an obvious and unprecedented expansion of Congress's limited powers under the Commerce Clause.
And they couldn't find a single precedent, a single historical basis for justifying what Congress did, could they?
No, in fact, the CBO, the Congressional Budget Office at the time, told Congress this is unprecedented. You can regulate when people buy and sell widgets, that's fine. What you can't do is make people buy cars. You can tell GM what kind of conditions they have to put in their contracts with their employees and the people who are purchasing their automobiles. What you can't do is tell somebody who lives in the city who doesn't want a car that they've got to go buy it, particularly when your only rationale is that this will help us offset the costs of our other regulation. And as the court pointed out, that's a principle without any limitation whatsoever.
And back to this tax point, because that's crucial, too. We've had the administration more than schizophrenic on it. It's got about 14 personalities on this issue. Basically, when the legislation was being passed, they were politically gutless. So there's no, this isn't a tax.
Right.
Because they could have taxed and probably gotten away with it, right? Instead, they claim now they claim it's a tax, but before that they claim, no, it's not a tax. Explain that point again.
They got hoisted by their own petard. They didn't want to say that, look, when we reach out and make you do this and pay a penalty if you don't do it, that is a tax, that's taking money out of Americans' pockets. So the court said, look, if Congress wants to exercise its broad taxing power, it can't call it a penalty. And, in fact, this is a penalty. It's a penalty for an unlawful act. It is unlawful for you, if this law goes into effect, not to own health insurance. So it's a penalty no different than a parking fine or anything else. And you can't use this excuse, which they invented only when they got into litigation and the courts started striking down their Commerce Clause arguments. They invented this new argument that it's somehow a tax, and no court anywhere has ever accepted this argument.
So what do the plaintiffs do now?
Well, we won, so it's now the ball's in the government's court, and I think it's important for everybody on both sides of this debate, people who like the act, people who don't like the act, to get this resolved. A lot of companies, a lot of individuals, and certainly a lot of states are going to have to be spending an awful lot of money over the next year or so to implement this extraordinarily expensive and complicated law. So it doesn't do anybody any good if there's uncertainty hanging like a cloud over this law. So I'm hoping the department where we used to work together does what it should do and not be political and get it up there to the Supreme Court right away so that every American can know whether or not this act and this individual mandate is going to survive.
Well, we know what we're dealing with. They're going to drag their feet like they did after the district court. So let me ask you this. I'm talking to Mike Carvin, one of the lead lawyers on this case, among others. A wonderful victory in the 11th Circuit Court of Appeal against the Obamacare individual mandate. Now, there are certain aspects that you or we did not prevail on. So why don't we take those up to the Supreme Court, and then the Justice Department has to follow.
There's a variety of options. I mean, obviously, they didn't agree with us in terms of the severability provisions, which that's legal lingo for the point that if you strike down one part of the act, does the whole statute go down or not? So that's a very complicated thing. As I say, I think we all hope that we can get it to the court in time and that the Justice Department does the right apolitical thing and we'll get it up there in a way that they're not stalling and we know one way or another. I mean, I think it's in everyone's interest, Democrats, Republicans, supporters of the act, people who don't, to find out whether or not this thing's going to be part of the American legal landscape.
Now, I had to hit my cough. Hold on a second. I have this horrible bronchitis, it turns out, Mike. I have to laugh a little because I know what they're doing over there at the Justice Department. Now, be honest, you don't trust... Well, maybe you can't say that. In the old days, you could, but now you have clients.
Yeah, exactly. Now I have to be a grown-up.
Yeah, well, let me stay in my juvenile mode. I do not trust these bastards. I'm sure they're going to drag their feet. So, and I'm also sure that in the recesses of your mind, you're thinking of ways to get this to the court as soon as you can. Am I right or not?
Mark, I never share my legal thinking, particularly even with somebody like you. So.
Okay. You mean not with millions of people? Okay. All right, well, good job. I hope you'll allow us in at the Supreme Court level, too. Landmark Legal Foundation.
Yeah, we're going to get up there soon enough, and we'd certainly like Landmark to give us their invaluable help.
Well, you guys did a great job. Absolutely terrific, and congratulations, Mike.
Appreciate it. Thanks a lot.
All right, God bless. Michael Carvin. There are others, too. Randy Barnett. I see I have an email from him in Hawaii. But I'd like to see the whole act go down. But something tells me this is how it's going to work. If we can knock out the individual mandate, we've knocked out a lot. But let me tell you something. I just don't trust this administration, the way it's moving to institute so much of this law. I just don't. And, of course, they're going to drag their feet before they get to the Supreme Court. Mike knows it. I'm sure he and others are trying to figure out some options. So basically, here's what the court said in its executive summary. The individual mandate was enacted as a regulatory penalty, not a revenue-raising tax, and cannot be sustained as an exercise of Congress's power under the Taxing and Spending Clause. The mandate, the individual mandate, is denominated as a penalty in the Act itself, and the legislative history and relevant case law confirm this reading of its function. Further, the individual mandate exceeds Congress's enumerated commerce power and is unconstitutional. This economic mandate represents a wholly novel and potentially unbounded assertion of congressional authority, the ability to compel Americans to purchase an expensive health insurance product they have elected not to buy and to make them repurchase that insurance product every month for their entire lives. We've not found any generally applicable, judicially enforceable, limiting principle that would permit us to uphold the mandate without obliterating the boundaries inherent in a system of enumerated congressional powers. Uniqueness is not a constitutional principle in any antecedent Supreme Court decision. The individual mandate also finds no refuge in the aggregation doctrine for decisions to abstain from the purchase of a product or service, whatever their cumulative effect, lack a sufficient nexus to commerce. In other words, part of what the government was arguing was, well, in the aggregate, if people don't pay into the system, then other people are going to have to pay for them. And what the court said is, What does that have to do with anything? The question is whether you have the power to do this under the Commerce Clause. Whether we should destroy the enumerated powers. Whether we should destroy these doctrines. Limits on Congress. Now, what stuns me about this, ladies and gentlemen, is it's a 2-to-1 vote on this issue. What stuns me is we have a Sixth Circuit, which has a very confusing outcome there with 3 judges giving 3 different opinions, really. What stuns me is we have district courts who've ruled the wrong way. I mean, most of you out there are not lawyers. Most of you are not experts on the Commerce Clause, but you have common sense. You're intelligent. You can follow the arguments. We have a Constitution that limits the power of the federal government by enumerating its powers, and that includes Congress. They don't have plenary power, the 3 branches of government. They have specific, limited roles in our society. We know what commerce is. If you're involved in commerce, really, if you're involved in interstate commerce, commerce between states, Congress has the power to regulate it and tax it. You know, historically, the purpose of the Commerce Clause was to promote commerce and trade, not to punish it and ban it and obstruct it. But even that said, the idea that the founding fathers, that the framers of the Constitution in Philadelphia, who were fighting for individual liberty, for state sovereignty, and a limited federal government to advance liberty. The idea that they would have said that this government would have the power to tell you what to buy, when to buy it, and how much to buy is so absurd it's off the charts.